Perfect. It being 5:30 on December 30th, I will call the meeting of the Shelburne Select Board to order. Welcome, everyone. Hope you all had great holidays. Hello,
Thank you.
Andrew.
Hello, good evening.
Hi.
Evening. Let's begin with a look at the minutes. I have been through them myself. Didn't find a thing to change. Everything was accurate. Andrew, you were there. You all set with the current ones?
I'm all set, yes.
Perfect. Um, we'll need a motion to move forward then,
I move to accept the minutes.
and I will second. Um, moved and seconded. Any further discussion? Hearing none. Andrew,
Aye.
and I am I. Motion passes to accept the minutes as is, 2-0. Department liaison reports. Tricia, you have been battling under the weather conditions. I would assume you may not have any this evening.
I have two quick ones. So, in my brief moments when I can do stuff,
Go for it.
um, uh, the emergency management, they are working with Trinity Church to become a food prep and distribution site in an emergency.
Yes, you do.
And then with MVP and Jeff and emergency management, you guys had said it would be okay to go ahead and talk to the Division of Ecological Restoration about the culvert replacement expression of interest. Jeff wanted to do that call as soon as possible. So we actually did it on December 23rd. So like that was the one thing I did that day. Um, and the DER rep actually thinks that we have a solid case regarding the culvert at Allen Brook that runs below Coleraine Shelburne Road. That culvert where it discharges into the Allen Brook on the east side of Coleraine Shelburne Road is actually way above the stream bed. So that's a high priority for them for repair. And he said that we could also add in up to two more high-risk crossings further downstream, and he pointed out two that we could do. So I would like to pursue this with for the town. The next step would be to apply, and it wouldn't be until February, whenever it comes out. He wasn't sure. This is a much quicker process than the first one we looked at with MEMA. They would hope to get the first round done. This would be for obviously a three-phase project where we have to do the data collection, then the engineering, and then the actual work. But they were very optimistic. At least it sounded like we had a good case. So I think it would be a great thing for us to pursue. It's correlates with our number one high priority with from the resilience plan that we developed last year, which is to create a resilient drainage plan focusing on the culverts.
Right.
That's all I got.
Terrific. Obviously, come closer to February when you're preparing that piece, bring it up, and I'm sure we'll be behind you on it.
Awesome.
And
Thank you.
liaison report.
Yes, I did not meet with Jeff this morning, so I don't have an update on the highway uh, work, but I will next time. It seemed like they're, other than responding to snow emergencies, or steady as she goes. They've wrapped up pretty much all of their construction projects for the year and are keeping their equipment tuned and ready for the winter needs. And just FYI, and I did get a call this morning from Angel asking for approval for 3 hours of overtime, which they were called out on Christmas Day. Um, they did get granted 2 hours off on the Friday, the Christmas Eve. So technically, they were only due 1 hour of overtime, but as their liaison, I said okay to the 3 hours and hoped that you all would agree. It seemed like a reasonable compensation for getting called out on Christmas. So, um, I hope I haven't overstepped in that, but there it is.
Totally
Um,
fine with me.
okay, good. And then the Pratt group has not did not meet in the interim, um, but will be coming forward during budget season, or the Arms group will. So we'll have more discussion probably of the Pratt lease then. Um, and then this is not a liaison role, but a project that I'm involved in that I want to keep you updated on. As you know from the minutes that we just approved, Rick and I authorized the go ahead on the two bid projects for the Memorial Hall Theater renovations. And then based on that approval, uh, Terry and I met with Bob Dean last week from the FERCog to engage them in putting out the public bid, which Bob agreed to do. And so we should be getting a contract from him shortly. And we are hopeful that they can keep us in their schedule and get that bid out in January to keep that project moving, because we have also gone forward with the purchase order for the direct contract, the Omnia bid for the seats in Memorial Hall. So that process is now underway. So that's, and then the third piece of this project, which we were kind of keeping under wraps, but I just got guidance today from Senator Mark's office about the Economic Development Bond Bill. And Senator Mark was kind enough to include an earmark in the bond bill for Memorial Hall Theater renovations to the tune of $250,000, which was passed in the bond bill. So that's the good news. The work ahead of us, according to his budget director, is that does not mean that a check is immediately forthcoming, but instead we have to now lobby the governor to include that earmark in her capital improvement plan for 2025 and to meet her priorities. So that's the next step in actually getting the funding. So it's not a done deal yet, but is one step forward in the process. So if that goes forward, then we can hopefully use that funding to move forward into phase 3 of our capital renovation plan for the theater, which will be fantastic. But as I said, we still have more work to do. So just wanted to keep you posted on that.
Well, that's fantastic. Congratulations on the effort to get it that far. Appreciate it.
It's great.
My police liaison report. The chief asked me just to reiterate the winter parking ban is still in effect. The blue lights either end of the parking lot behind the stores on Bridge Street, the postings, the Blackbird notification, all of that. If you're listening as a resident and haven't got up to speed, please check out the town website. It has all the details of where you can and can't park to avoid fairly substantial towing bill in the event of a snowstorm.
Oh,
Uh,
Rick, I just in reading the minutes, I had one further suggestion on where we might put a notice about the blue light special there. And that would be in the over the fall cable calendar. We could create a little tile that would just run in the winter half of the year, you know. I wouldn't, that doesn't cost anything, but it just, in reading the minutes, it jogged me into thinking that's another place to put it. I don't know how well read that is, but there it is.
it's interesting. We talk about our vast audience as we have our meetings, and I can't tell you how many times I'm stopped on the street and say, "Hey, I watch you guys on television and comment on something we did or didn't do." It's amazing how many people actually view it later, as opposed to seeing it while it's happening or shortly thereafter. So I think that's a worthwhile thing to pursue. Today on Main Street, there was a car crash into a house. It had heavy fire and police presence, obviously. The driver of the vehicle was taken to the hospital. No word further on that. The sole occupant of the house was uninjured, but a vehicle and house accident on Main Street is a little rare, so I thought I'd mention it. We also have, you may have seen in the recorder, the chief put in a reminder of folks to keep their cars locked overnight. We had 2 stolen that ended up with a lot of damage in Charlemont, I think. The investigation actually is progressing quite quickly, and there's even been video of the suspects. So hopefully that'll be resolved soon, but the police are all over it.
That was a very bizarre item in the news there. I can't even begin to fathom what was going on there.
Yes, they did a lot of damage with one of them to the Charlemont Fairgrounds,
Yeah.
in addition to the vehicle, of course. But yeah, unfortunate. Courier Knives, Shelburne Falls, we're not immune. A non-liaison report, but since I was appointed to the school district negotiating subcommittee, I can report that we did meet again last week. Again, it was executive session, so I can't share anything that happened other than to let you know it is moving forward, and we've already had the first meeting set with the paraprofessionals group in very early January. So moving forward, and I'll keep you appraised with whatever I can as it happens.
And Rick, just as an FYI, I apologize. I was not able to attend the budget meeting of the school, so
No
don't
problem.
have any updates on that, but we'll try to get back in the mix there.
We all had extra meetings, that's for sure. It's been crazy, hasn't it? We have guests tonight from the Shelburne Planning Board. We have Chair John Wheeler. We have members Will Flanders and Paul Hollings. I think Will's on. Scheduled
And Susan Durkee, I believe.
Okay, Susan.
Yeah.
Hi.
Wow. So great representation, and you folks have put in front of us 4 bylaws, 2 general bylaws, 2 zoning bylaws, and requested this time to kick them around. We got them almost I think a day over 2 weeks ago. And what would you like to do? Ask questions or hear what we may have to say?
Well, first of all, we have a quorum of the planning board here, so I had to post the meeting. So I guess the procedure is I should call the meeting of the planning board to order. I think
Okay.
Yeah.
So I get my recording going here too. So I'll call the meeting of the Shelburne Planning Board to order at 5:45. And we're here meeting with I'll turn my recording on here too, so I can get that to Faye Whitney.
Perfect.
Okay, so I've called the meeting of the Shelburne Planning Board to order at 5:45. We're being recorded, and we came to seek input from the Selectboard about the 4 proposed bylaws that we have here. And since we sent them, Paul Hollings noticed that we have a newer version of the short-term rental bylaw, because we spent some time at our last meeting talking with Randy Crozier from the FERCog. And I think Paul said the version that you got there weren't a lot of big changes from what we sent you. So I guess if you've had a chance to read them over, we'd like to get your input.
Okay. The first one on our agenda is short-term rental bylaw. So any input from my fellow board members after reviewing that? I know it's been 2 weeks, but it's also been holiday time and getaway vacation time. But if you've had time and have some thoughts,
I had
now.
a I had a few questions, but I see Andrew does too. So whoever wants.
Go ahead, Tricia.
There were a couple of things that drew my attention about the bylaw, and there were an instance where the town clerk was going to be issuing a certificate of registration and the Board of Health was going to promulgate regulations. I just wanted to make sure that both of those entities were aware that they might have some additional work coming their way if this passes, or if you had consulted them about what they thought would work for this.
John, would you like me
No.
to answer?
Yes, I was going to say, Will Flanders and Paul did the majority of the work
Will's
on
here
this,
too.
so I'll let them respond.
Go ahead, Paul.
Yeah, so we've had several conversations with Joe Judd about it, and also we had Randy Crozier come from FERCog to our last meeting, and he provided some excellent input based in part on just his extensive knowledge of all of Franklin County, but also based upon his experience, FERCog's experience with the implementing the Buckland ordinance. And he thought that ours was an excellent model, which could in fact be used in Franklin County. He had a few changes to suggest, and Will and I met and kind of incorporated, and Will actually did the bulk of the technical writing work on that. Unfortunately, you didn't get that version, but it's not significantly different than as John said, than the version you did get. But so we've also met with the ZBA to talk about these. So we've been trying to get as much input as possible.
That's great. Thank you. I had another couple of questions. So I had a question about section 3.3, that's where the owner of each short-term residential rental is supposed to keep a register containing the name of every person for up to who's stayed there for up to 2 years. I was just wondering if that's a normal process that landlords go through, or is there a separate purpose just because this is short-term rental?
I think it's more like a hotel where you keep a record of that as well. It is in the Buckland ordinance. I've seen it in another ordinance. We've looked at a lot of other towns. So I think it is fairly normal.
I mean,
but
the key is all this short-term rental stuff is there's no normal. We're making this up as we go along, trying to come up with what makes sense. And so it's but I'm not aware that the regular landlords keep a journal of the people they've rented to over the years.
Yeah, I was kind of just wondering what the purpose of that is, and if that might get kicked back from the Attorney General for some other privacy reasons, because I mean, just offhand, I don't see why anybody would need to keep that for 2 years. So I don't know if that's a legal requirement. If it sounds like it's just like, well, everybody else did it, so we're doing it too. I don't know that's,
So I can just say one thing about that is that the Attorney General approved the Buckland ordinance, which does have it in there. So that technical problem wouldn't be there. But I think we can go back and ask that question to ourselves.
One thing I can imagine that might be useful to have is if there are problems, in other words, if there are crimes, for example, committed by somebody who is a short-term renter, having a record of when that person was there, and just that might be a useful thing to have. But I'm not sure why Buckland put it in.
Yeah, I kind of thought of that for crimes, but I mean, 2 years after the fact, that would be, it just seems like a little extraordinary. But okay, so let's move on to 3.4. There was something about timely, that if violations arise within the registration period and are not corrected in a timely manner. I don't like things that say timely, because my timely might be a lot shorter than yours. Is there some way that we could provide more specificity here, or is that more acceptable legally to leave it as just saying things need to be corrected in a timely manner?
My opinion about that is I rather like the word timely because it's relevant to whatever the issue is.
Right.
So, if it's, there's there's a big party going on, the timely response is end the party. If it, so I think it depends entirely on what you're trying to fix. And so, I have in a typical landlord situation, all different kinds of things happen. And, you can expect your tenant or your landlord to fix it based on whatever it is, rather than, so I think, so it's sort of been the category of reasonableness and timeliness and all those things that are dependent on the circumstances.
Okay. Thank you. And looking at 3.7, do you think that we could reduce the number of parking spaces? So we want to have a minimum of one off-street parking space for each room for overnight accommodation. I was thinking we maybe just delete for each room, because that could be a lot of parking spaces, although I know you did say you don't want it to exceed more than 4. But I've noticed with other areas that are trying to increase affordable housing and the number of people living in their towns or municipalities, that one of the things that they're doing is to eliminate some of the parking restrictions, because it eases that burden on the landlords and developers. So I wonder if we could consider lowering that maximum limit to it shouldn't exceed more than 2 spaces that have to be required, and 1 space per dwelling, and a maximum of 2.
Okay with me. It's
I think you folks asked us for feedback, and that's what you're
right.
getting.
Yeah, no, that's good
Okay.
feedback. It's
Make
Yeah.
your notes and do as you see fit, but
sure.
we'll just keep it coming.
Right.
Okay.
So I think
Yeah,
it's
that's something we should definitely talk with the zoning board also when it comes to
yeah, right.
parking.
Exactly.
They often give us some input on that too, but it sounds like a good idea to me to require fewer parking
Yeah,
spaces
sure.
if possible.
That's right.
Okay.
I think that the new housing law that just came out says you can't require too many parking spots, and especially if you have access to public transport. And so but that focuses on making it easier to create more affordable housing.
Right.
And so this, we're not trying to create as much short-term rental housing as we can.
There's a big
So-
difference too between the housing and tourists coming in for a couple of days. They're almost always going to have a car. So I think we
Right.
have to consider what the impact is there. As people, I think the whole thing about housing is not requiring that so people can get around otherwise.
Right.
I was just wondering also in the section 4, if we have any idea of how many residents these changes are going to impact right now, regarding that the all existing owner-occupied short-term residential rentals have to meet the requirement and standards of this chapter within 6 months, and then non-owner occupied ones have to go through a different process. Do we have an idea of how many people that's going to impact?
There are currently 39 registered short-term rentals, or it's 41 maybe. It's right around 40 anyway.
Around 40?
And how many of those are owner occupied and non-owner occupied, we don't know for sure. But this has been written in such a way that existing ones are grandparented in, provided that they have been. So the difference is the owner occupied can do it by right. The non-owner occupied who are already existing and have already been following, obeying the laws that currently exist about registering with the state Division of Revenue and paying taxes and the like, they are also going to be able to continue in operation. But it's just a requirement there that they have already done that. So if they've been existing illegally for a while now, they may be impacted. We just don't know how many of those are.
Okay. And then in the last one you had on 5.1, and I think maybe this is part of what your updates include. It said check Buckland bylaws and make appropriate reference.
We took that out. Randy Crozier said that it's evident in state law, I believe, that the Board of Health is the enforcing person, so that we didn't have to actually reference. It's not in our town bylaws. It is in the Buckland bylaws, and we were using theirs as a sort of a jumping off point. But I don't think we need to reference the town bylaws.
Thank you.
Andrew.
Yeah, thank you. I do have a few questions and a few small editorial suggestions. My main question is in the purpose statement. One of the purposes you cite is to minimize reductions to available long-term rental housing. But I don't see a mechanism in this bylaw by which you propose to do that.
What it would do, Andrew, is to limit the conversion of existing rentals to short-term rentals, existing long-term rentals.
How does it do that?
By preventing non-owner occupied, which is essentially sort of investor-owned.
Right, but where does it say that?
So the way it's worded, it says 4.1.2. So it says that existing non-owner occupied can continue, but it does no provision for them to be permitted. Oh, and then also in the table of use regulations, if you go to that at the very end, the very last one, short-term residential units with non-owner occupied are not permitted.
You're saying the commercial, in the commercial you've crossed out, right?
No, all. If you look at the very last, the table of use regulations, the very bottom one.
Yeah.
It says short-term residential units with any number of rooms for overnight accommodations, available rent with or without kitchen facilities in a non-owner occupied residential dwelling. Those are not permitted. Those are already existing will be grandparented in, but we would not permit additional ones to start up.
Okay, so that was what I had the question about. So that's your primary mechanism, is that last table of use item there.
Yep.
Okay. Yeah, I was thinking, I don't know if it makes sense to make that just plainer to people in terms of saying, for example, no new permits for non-owner occupied STRs shall be granted after X date. Just because
that's it's already in. The rules for granting permits and registrations require owner occupied. It's in the definitions, it's in all that stuff. And so only owner occupied people will be able to do short-term rentals, and the people who are already doing it and are in conformance with the current rules get grandfathered, but nobody else get grandfathered. It's like the whole thing is designed to simply require owner occupied.
I understand what you're saying, and I agree with your intent. It's just that the way that it's written is not clear to me as a reader that that's what you're doing, so that if somebody is in the investment property business and they're reading this bylaw, we should just come right out and say it to them, you know.
We can take another look at that.
Yeah, all
Um,
right. That's
Perhaps we'll talk that over. Perhaps something could be added to the purpose to make it a little more obvious, but
yeah. Or we could add something to that 4.2, whatever it is, that says, you know, after this date, no new, non-owner occupied, people will be
that
allowed.
would be helpful, I think.
So,
Yeah, because when in reading 4.2, it was not clear to me that in any way terminated a non-owner occupied short-term rental.
yeah, it
It's
doesn't
just
terminate it. It just doesn't. It just there is not. There's nobody you can't be grandfathered in if you're not already in.
Yeah.
right, right. But I think just having that grandfather message,
Yeah.
and here's the end date, might make that clearer.
Right.
Um, anyway, so a couple of other, and these are just small editorial things. In short-term rental, section 1, um, after the minimizing to, oh no, I'm sorry. Where did I see that? Uh,
What's the point you're looking for,
oh,
Andrew?
here. In section 1, in the definitions, dwelling room in one of these dwellings for overnight accommodations for not more than 31 consecutive days, you might want to add the words to the same party there, just so that it's clear that it's not about 31, because they rent consecutively for 31 days, but to different people.
Yeah, good point.
Yeah.
Um, in section, hang on a second. In section 2.2, you have an extra A before the words 2 hours on line 3. In section 2.4, you have you should add an S to registrations.
section,
2.4?
which was that?
2.4 has an S on it.
I'm sorry, you should take the S off of registrations in 2.4,
Okay.
I think. Um,
Oh, can we go back to 2.2? There's no C. You have A, contact information, you have B, and then you have D
good catch.
before we go moving on.
In section 3.5, you have the words shall be that could be deleted, I believe.
That was actually edited, and Will edited that out, but you got the old version.
Oh, okay, good. Section 3.6, the word adult should probably be plural.
Hmm.
And I think that's it for
I
me.
have one for 3.7. And where it says a minimum of one off-street parking space shall be provided. I don't know if you want to have for each room based on our conversation that we had for overnight accommodation, but that was another idea. And then I think there was one more. Oh, yeah. Down on the table of use regulations, where you have deleted short-term vacation rental tourist home, it has 2 asterisks next to it. So I'm assuming the asterisk text that follows would also be deleted, but I don't know if it's also there. but that would have to be apparent.
Yep.
And
We'll have to look at that.
probably delete that definition in the definition section, probably too.
Yep.
Great. Well, thank you. I'm in favor of this bylaw, and I hope we get it tuned up and to the voters.
Yeah. I really thank you all for all the work that you put into this.
Great.
Well, that's one of the things we wanted to know is what the select board and the zoning board feels about this. Is it something we should propose? And I think we've got some good suggestions from you, and the more people we can have look this over, the more things that get caught. So
You do
Yeah.
already have your hearing scheduled for February 25th?
It's on our calendar. We haven't done any publication on it.
Okay.
But yeah, that's the day we've scheduled it.
yeah, and I think we're on our schedule. We're hoping to have we've got a regular meeting on January 7th, and then an information session on January 21st, and then hopefully a public hearing by the 25th of February.
Great. I
Um,
miss you guys, by the way.
Yep. My fellow select board members have done a great job and left me with like two things that I think so. Great job, you guys. Proofreaders all. It's a curse. One thing that might be appropriate under regulations, perhaps, or complaint process and enforcement based on issues we've just recently experienced, may be to state that it's the requirement of the owner to notify renters of the winter parking ban.
Yep.
It was a mess the first time we had towings this year, and it's one of the things that we suggested was not just short-term rental landlords, but landlords for regular rentals be more diligent in advising their tenants that there is one and not let it go through the cracks. The only other question I had, and I think it may be nuanced, but it wasn't stated, who issues the special permit?
I think it was the ZBA up above. Didn't it
No.
say that they were the
Special
special permit
That's right.
granting authority?
Yeah, we just added something to the zoning bylaw last year that said unless the zoning bylaw says specifically that somebody else is, it's the ZBA who does special permits.
So I think you should write it in there then, because one of your other ones did specifically mention the ZBA as the granting authority, and you continued on referencing it as the granting authority multiple times, but you had initially said the granting authority would be the zoning board. In this one, it wasn't clear to me. Is it you look at 2.2, is it the town clerk? Is it the select board? If you just state it, it seems like the person who cares nothing about all the rest of our zoning bylaws and is looking at just this one shouldn't be expected to have seen that elsewhere, I think. Just my personal
Can I clarify?
Yeah.
Can I clarify here? The only place we got special permits is short-term for 3 to 4 units. The 1 to 2 is not going through the ZBA.
Right.
That's at least my understanding. I mean, John and Will are much more experienced than I am here, but
Those are by right, but the special permit is for the
That's right.
short-term.
Yeah, it doesn't
3 to
hurt to
4
add.
months.
I think it's
Yeah.
a good clarification to add the ZBA for those,
I mean,
larger.
I've been around the farm a while, and my guess was it was Board of Health. By
Right.
reading everything else, and all the input you've got, I would have assumed it would be the Board of Health who gave it. So,
FERCog has a role in that, yes.
yep. So,
Right, but we can certainly add something to this bylaw that says if you want to get a special permit as required by the table of uses, then it's through the ZBA. That's an easy, another asterisk in the But it could be in the bylaw as well as the table of uses.
Right. You guys sorry you asked for input yet?
No,
No,
I just-
this,
all good ideas.
I just want to add that we will have, an application form, and that it will be submitted to the Board of Health, FERCog, to process. We've got some input from Joe Judd on the form and how to do it, and Buckland has one, so that's sort of an implementation phase for us.
Terrific. I think the next one on your list for input is the general town bylaw for mobile food establishments.
now Will did most of the work on writing this one, so
Okay.
I guess.
Thank you very much, because I know this one has been in the hopper for quite some time. And I have a few questions, or unless you want to go first, Will.
No, just go. I'm interested in feedback. So
Okay.
whatever your responses are.
Okay. So under 21.4, so this is assuming, this becomes the new chapter 21 to the town bylaw.
Right.
There's a time for operations from 8 a.m. to 8 p.m. I know that in the past there was a different time frame proposed. I was wondering how you all settled on that, or is that something that could change after your public hearing? Or how did you, I think that in the previous version from last year, it was 7 a.m. to 9 p.m.
Yeah, I don't actually remember what it was from last year. It just
I pulled it up, so
it's all right. There you go. So I put that in there just because it seems like for the short term, the one under a week, it's gonna be mostly those people who are they're here for Moonlight Magic, which is over by about 8, and so it's every time at the end of Moonlight Magic, people are breaking down at 8 o'clock. So that seemed like 8 to 8 seemed like a good time, but I'm not attached to it.
okay.
You might want to, if that's your main capture there that you're trying to wrap this around, I would give them a little bit more leeway than 8, but myself, just because that seems like cutting them off, kind of right
So
there.
7 to 9.
Yeah.
Yeah.
I'm not
I
attached.
think one of the
Yeah.
issues was if somebody wanted to pull in a coffee vendor truck, then they might want to be there earlier in the morning before
Right.
the other places
Okay.
opened. And
That's
then
fine.
I agree with Andrew. If they have to leave by 8, they're going to start breaking down before 8. So under 21.5, you mentioned fees. So shouldn't we have fees attached to this bylaw at this time, or is that something that gets discussed at a later date?
It's I think there's something in there that says the fees are set by the select board from time to time. So whatever you all think they should be. I mean, this is a general bylaw. This actually will not be in the zoning bylaw because it's a general. And
Right.
so it's up to you to, what do you think is a reasonable, fee schedule for the various types of permits?
So I think we should include the fees right here in this line, since if we decide.
Terry has a
The
question.
fees are set by the FERCog. They do the licensing for food establishments.
Okay.
But
So-
this is a fee for the registration,
Okay.
which is a different thing. And so, I mean, the select board could decide not to have any additional fees, and because the people were paying a fee, to the FERCog.
Yeah,
But it's just the discussion or the discretion is in the select board.
Okay. I would, So in this particular case of 21.5, I'd like to separate the two issues regarding ice cream trucks and the fees, because I would propose making 21.5 just refer to that sentence that we have there. The Select Board and Board of Health can establish general or specific to a particular permit terms and conditions, permits and fees for such permits, and then make another separate line that the Select Board shall comply with the provisions of MGL Chapter 270, Section 25 with respect to ice cream trucks, so that that's separately called out. It's not really a fee question,
Right.
but it's
Okay.
right.
Yeah, I see.
Yep.
Sure, that's easy.
That
Just
would be easy.
a new sub paragraph.
Yeah, I don't, do you recommend having it be a 21.5.1 or a 21.6? It seems to me like it's a separate issue altogether from the fees, and it should be 21.6.
That's fine with me.
Okay,
That makes sense.
okay.
Yeah, no, it's I mean, we're going for clarity. Whatever it is, we'll make it clear is what we want.
Okay, and then the last thing that I had was the previous proposal also included some stipulations about tables, signs, restrictions on the use of public waste receptacles. There were specifications on trash removal requirements and safety of pedestrian and vehicular traffic. So I would like to see those included in this general bylaw as well. I think those were important considerations that had been discussed earlier. And I think that we want to make sure that anybody who shows up here, that they're disposing of their own trash, that they are not going to throw everything into the public bins, that they're, complying with water and stuff. Some of those things are not included in what FERCog would require, but
Right.
I think
Yeah.
we need to do that. And we should think about what kind of signs they can use. I don't think we want everybody, what do you call those feather signs? Yeah,
Mm.
those big ones,
Flag-
or
Flags.
the flags, all of that
There is a separate, Tricia, there's a separate bylaw on temporary
Signs.
signage. Yeah.
I know, but I maybe it would be good to include a reference to that as well. And then I think there was something else about wherever the vehicle was going to set up shop, that they needed to be aware of not impeding pedestrian or vehicular traffic, but also not making it dangerous for somebody to get around them, even if they weren't impeding the traffic, but that they weren't going to make a pedestrian, they weren't blocking a sidewalk or impeding visuals, so they would be harmed. So I would like to see those added back in as well.
Okay.
That's all I have for that. Thank you
Right.
again.
Andrew?
Yeah, just a couple of questions. One of the things that struck me in reading this bylaw is that the one mobile building food establishment that we have in town is Ozma's Kitchen. And it looks to me like this bylaw would not permit that business to operate. Am I misreading this?
I think they're grandfathered.
Okay, so you're saying that business is grandfathered, but we would not permit another one like it.
That's right.
Okay.
There's actually two pieces in this bylaw. One of the pieces is just preventing or prohibiting the use of temporary buildings, including ones on wheels, and also ones where they bring them in on a truck and put them on the ground with a forklift. So there's two different, a little research I did, there's two different kinds of temporary buildings, and those are the two. And this is something I'm passionate about, which is we don't want every empty lot in the downtown village commercial to end up with a temporary building on it.
I'm in agreement with you.
I don't want that to happen, and I mean, the people, we have a park right there, where the Sibley's building was, but
Singley's building, yeah.
Singley's building. So
Yeah.
that could be, when that lease is up, those owners could decide to put in a couple of temporary buildings at this
Right.
point because there's no rule against it. And I think I don't think we want it.
Right. Right. No, I'm in agreement. I was just wondering about that since that is the
Yeah,
one
no, I think
business we have. Yeah.
I think we've had questions already about that
yeah, right.
issue, and I
Yeah.
think maybe we should make it maybe more clear that that one is grandfathered. I know that's a question that's going to come up, but we're thinking about the future.
Right.
Right.
We could put in
Okay.
a similar grandfathering reference as we did in the other one, in the
Mhm.
short-term rentals. It says,
Isn't there a statement in the zoning bylaws that says something about pre-existing?
yeah, it's a state law as well.
Yeah.
But it doesn't hurt to make it explicit.
Again, the people that are going to read this and apply for it, they don't know that.
That's right. Exactly.
Just make it easy. Put it in there.
Exactly.
All about clarity, right?
Yeah.
Yeah.
Yep.
The other
And-
thing to be aware of is that this is not just about village commercial.
Right.
This is about, anywhere. It's like, it's, for whatever reason, historically, we have prohibited trailer homes as a residence or business. And we've, unless you create a mobile home park. And so the definition changes, add the the temporary buildings that are not on wheels. It's like, because it's a big thing that they bring one in and take it off the truck with a
Yeah.
so it's so it just expands that, and it makes it really clear that you can't do that for residential or commercial.
Right. So I have a couple other questions. Just in thinking back over the years of the different kinds of enterprises that would fall under this regulation or this bylaw, clearly Moonlight Magic is one set of vendors that happens, episodically. The BSE started a similar sort of little festival, invited a bunch of vendors onto their property. So that all makes sense. We have had food carts, on sidewalks. I don't think would those be regulated by this or not?
They would be prohibited.
Prohibited. Okay.
Yeah.
Unless they were on the owner's property.
Even then, I'm not sure about that. I think the goal is to have, if we have, other than, well, there's the long-term people like Apex Orchards that has a trailer all the time, and they're open on weekends or whatever they have. They get an annual permit.
Right.
It's on their own property.
But Tony Palumbo's little hot dog cart would not be permitted under this then.
No, unless Tony had a 1 week, permit.
I see. Okay, but he couldn't park down by the bridge all summer long and sell hot dogs then.
No.
Okay. And then the other question was just that the classic food business that we have not had in town, but we could in the future, are food trucks, which you see, in downtown Boston or Washington, D.C. or whatever. They pull up to a curb and they sell lunch to people and stuff. How does this bylaw address the future food trucks of the world who want to sell food in Shelburne Falls?
They need to get a short-term, 1 to 7 day permit from you all.
Okay.
In other words, it's like those people, and they have to park themselves in a parallel parking spot rather than an angled parking spot.
Okay. So we're not envisioning somebody selling food out of a truck over more than a 1 to 7 day period.
Or, I mean, that would be up to you about how many 7 day periods you give people.
I see. We
You
could
know,
keep renewing them
you
if
could
they
do
wanted
that
to stay here.
theoretically. It's
Okay.
just that you're going to be, people are going to have to come in and say, this is what we want to do. And then you all, as the select board, decide what you're going to let them do.
Okay. And then in terms of the overall number of permits that we would grant at any one time, is that just up to the discretion of the select
Select
board?
board. Yeah.
Okay. So we would theoretically just fit that to the event being envisioned or whatever.
Where you
Yeah.
could say, we've already given one 7 day permit for somebody to park on Deerfield Street. Okay,
Right.
so we're not going to give another permit for Deerfield Street,
Hmm.
but maybe some other place that has a parallel parking, you know,
Right.
that would be the idea is to give you all discretion to decide what makes sense in the moment.
Okay. Good. Those were all my questions.
My only comment would be on item 21.1. Again, for your goal of clarity, I would think it would behoove us to reword that so that, again, it told the person who's coming to specifically ask about what are the rules and regs on food truck or a mobile food business of the process. And your wording in one of the other ones was something to the effect of a preliminary meeting with the planning board is required. I think some wording about that to meet a preliminary meeting with the select board is required. And then that the permit would be issued by the Board of Health and then come back to the select board for final approval. Something that showed them what are the steps? How do I do this? And that wasn't clear to me from any of the verbiage, and that was the one that seemed to address it. But how could they? I mean, the select board would never approve one without the Board of Health having approved it. So how can the Board of Health issue one without knowing that we've seen it and told them to go forward or something? So food for thought, for clarity, for the applicant himself.
All right, great, thanks.
All right. We are up to battery storage. This is a zoning bylaw, the long one.
Right.
You're up, Tricia.
Okay, I was just writing my notes from the last one.
This one, Faith Williams did a lot of work on this one. And we did run this, as I remember, we ran this by the ZBA, and it was a much shorter, maybe simpler one that we thought was good at first. But then when I think it was John Taylor looked at it, and he suggested that we model this bylaw after the telecommunications bylaw. So that's how it ended up so long. And again, Faith did most of the work on this, but couldn't be here tonight. But
John, can I add one thing to this? Is just that the state prohibits us from banning them outright. So what we've been trying to do is to draft something that allows them but restricts them in a way that is favorable to us.
And I think, didn't we look at, was it the Oakham bylaw that had passed? And a lot of what we put in there came from I think it was Oakham bylaw that actually did pass through the Attorney General's office and was approved. So we wanted to stay away from the things that like Wendell and Shutesbury did that got sent back. So
we've gotten some feedback from Al Norman, who has been very involved in the Wendell and Shutesbury battles, but they don't seem to be getting anywhere. They've been rejected twice.
What's been rejected twice?
Wendell and Shutesbury both prohibited battery energy storage systems. And they first did it as a zoning bylaw in Wendell, and that got rejected by the AG's office. So then they did a general bylaw saying that it was all about safety, and that got rejected. So they're back to square one. Oakham, as John pointed out, they did pass one which permits it but restricts it.
Okay. So I had a question about the nuclear powered electric generating facilities. And this is just something as food for thought. There, within the resilience world, there's a push for creating smaller scale nuclear generating facilities because they are less hazardous than the big ones that everybody's freaked out about. They actually can be safe because they're so small. They have a limited amount of material that they would be using, and they are very clean energy except for their, the waste products, but they don't produce greenhouse gases or anything like that. So I'm wondering if we want to consider that instead of banning them outright, but allowing special permits perhaps for some areas, just so that we don't box ourselves in if there comes a time when we can avail ourselves of that technology, again, on a very small scale, to help with the greenhouse gas problem. Just a
Tricia,
question.
are you referencing the thorium electrical generating facilities that are very small but different kind of it's not using uranium but thorium?
Oh, I actually don't know that answer, Will.
Okay.
I just know that there are some that are on a smaller scale. And then we've also got, they are making a lot of progress with fusion technology. So, which is technically a nuclear reaction as well. So we wouldn't want to also exclude that as a possibility.
I have heard some about the smaller, a different type of nuclear plants. I don't know the details about how they work or anything, but I know that they're supposed to be much safer and much more environmentally friendly. And
I'm a little confused, Tricia. You're not talking about this particular bylaw here, which is battery energy storage. You're talking about adding a new bylaw addressing these other devices?
Well, I'm looking at page
one, nuclear.
8 of
What page are you on?
I'm on page 8 of the select board meeting materials, which has the heading energy generation uses, which has the use
Oh, just a
table.
table.
So that the table is the first 8 lines of that table are what's existing right now in the bylaws. The only thing we've added is the battery energy storage facility at the bottom.
Mm-hmm. So my thought is if we're going to discuss this whole bylaw, then this is something that now is, how the technology is advancing, that there might be a space to have nuclear powered electric generating facilities of a certain scale by special permit, but we don't want to just say they're not available at all. If we're going to revise the bylaw, I just wanted to bring that forward, that maybe this is something we should consider as well.
Yeah, I would say that's a completely different topic, which we could address next year.
Okay.
Like I think it's a good idea because this new technology it has potential. But
I would say, Will, if the new technology has a different solution than the current nuclear plants regarding long-term storage of nuclear waste, I would be open to considering it. But if they're talking about storing radioactive materials on site for ad infinitum, or don't have any plan for dismantling your hot building, I'm not in favor of it. Even if it's cleaner than a coal plant, I'm not in favor of it.
That's why I'm suggesting that this is a project that we can undertake to look at the potential, what are the potentials, what are the risks, does it have long-term storage issues or not, and so on. So I'm open to thinking about it, but it has exactly the same concerns that you have.
Yeah.
Yeah, I
There's
think
no
we
Okay.
question about it.
we kind of took a left at the right-hand turn there. That
Yeah,
is,
sorry.
that's a whole different bylaw. That if this one got passed and got through the Attorney General's office, etc., then you might want to go back and look at this other one. If this one's thrown out, you don't need to deal with it until other options become available. So I think we should stay focused on what you're putting before us. And you're
And I
asking.
apologize for that. I didn't realize because it didn't say like this is where the addition was to this table. So yeah, I'm sorry about that.
No problem.
So
Any,
I actually had a couple of things about this specifically. You do mention in 19.4.8 about the operation and maintenance. You reference stormwater and vegetation controls, and I don't know if this later on in the bylaw, there's mention of compliance with stormwater and wetlands regulations. But I don't know if you need to put a reference in here too. That might be like what Rick says, just to keep it really clear, like, hey, you need to make sure that you do this as well. There's a few typos in here. Also on 19.6.4 regarding roads, it says access to roads to BESS installations shall be constructed to minimize grading, stormwater runoff control, removal of stone walls or trees, and to minimize impacts to environmental blah, blah, blah. I think that you don't want to have that word control in there because you want things to be constructed to minimize grading, stormwater and runoff, removal of stone walls or trees, and impacts to environmental, wetland, or historic sources. So my recommendation is to remove the word control and the second iterance of to minimize. For that's
Which
clear.
number was that, Tricia?
This was on 19.6.4 regarding the roads. And then in 19.6.6 under hazardous materials, down at the very bottom, it says a list of any hazardous materials located on the site and a plan to prevent the release shall provided to the fire chief. I would recommend adding also the emergency management director. You do reference the emergency management director later in something else. Thank you. That's awesome. I would also like to see it here. I think that's great. I also think maybe even the select board would need to know about that because in the event of an emergency, the chair of the select board is actually the person who has to declare an emergency. And so it would be important that the select board is aware of what that is. So on 19.7.2 regarding the grade of the land, the last sentence says locating BESSs on grades in excess of 10% should be avoided to the maximum extent feasible. Is this one of those things where we just can't prohibit it? Because I'm wondering if at that grade, that's pretty steep. In the event of a large water event, a large precipitation event, if there was a lot of runoff or some issue like that that could erode underneath this facility, that could be quite dangerous if it lost its footings. So I'm wondering, can we just prohibit that locating BSSs on grades in excess of 10% are not allowed? Or is that going to get kicked back?
I think that it has to do with where the energy production is. So if you have, let's say you had a wind farm and you needed to have the battery storage facility within a reasonable proximity to the place where the energy is being generated, if that's in a hilly place, I don't know that they would say you could prohibit that. Like it can't be miles away, right? So that's where I think the word feasible comes in. Like if it's at all feasible to have it not on a steep place, then that's what you go for. But if that means making it so that it's too far from the energy producing source to be, kind of effective, then they would probably say, no, you can't prohibit that.
But I'm with Tricia on this one, though. I think we should write this as strictly as possible and take our chances with the AG. Because I think some of these things that say to the maximum extent possible are wide open. And now that now that you say it, it prompts me. Even the next line too, 1973 says to the maximum extent possible. I think Faith did great work on this. A lot of it that was borrowed from others, and I suspect that that's why that language is there. But I think we might go back and sort of view it with an eye towards making it stricter if we can, and send it to the AG's office and see what happens. As long as we're not prohibiting it, it seems like things are getting through. The Oakham one is fairly restrictive, I think, when I read it.
The other
That's great.
possibility is that if we like the steepness of the hill of the site, for example, if part of what we could add to that is infrastructure that would prohibit or minimize the chances of a major precipitation event washing the whole thing out. In other words, it's if you have to have it on a steep slope, then what are you going to do to make sure it doesn't wash away? And have that could be added in there as something that's for other areas where we think it's potentially dangerous from an environmental perspective, or due to rain or flooding or whatever, we can put in something like that.
There are, maps available from the Commonwealth that can identify areas of, potential flooding and erosion and stuff, given the projections for climate change and what's going to happen.
Right.
So that would be a good thing to reference for that, that it's in accordance with this, not just it's in accordance with future climate projections and not just
Right.
what we've experienced so far. I like that idea. Also, Paul, you picked up on my next comment on the 19.7.3. I had highlighted that. Can we delete to the maximum extent feasible? On 19.7.5, regarding the security fencing, I think we should just require a 6-foot chain link fence as a minimum. It just says that the BESS and related equipment typically require a 6-foot chain link fence. I think we just say we're going to require it as a minimum.
Good point.
Those facilities have recently been, or some energy generating facilities have recently been targets of suspected terrorism and vandalism. And so we want to make sure that those areas are as inaccessible as possible.
Right.
Yep.
I think if I could get a little bit of clarity on 19.8.3, please, regarding the annual reporting. The amount of electricity generated by the facility, so if you can just explain to me, the BESS is the storage facility. After the electricity's been generated, it gets stored into those batteries, right?
Right.
So the generation is actually not happening right there. So I was a little bit confused about how this fits in here.
Maybe the word generated should be replaced with the word stored.
If that's what we mean, yeah, I think that.
Yeah, that's a good point, though. Yeah.
Yeah.
Okay.
I think that part of what was the model for this one was our large scale solar
Solar.
bylaw. So that may be just a word that got didn't get translated into the new version.
Okay. On 19.9.4, it looked like there was some punctuation that was missing. It just kind of ran on, and I wanted to make sure that it meant what you want it to mean. So proponents of BESSs shall provide a form of surety either through an escrow account bond or other form of surety approved by the SBGA to cover the cost of removal. In the event the town must remove the installation, I think you need a comma or two in there, and stabilization or revegetation of the landscape. I'll let you guys figure that out. And then under 19.10.2, B, required documents. Under number 1, the architectural, engineering, and site plans showing, I think you can merge the sub bullets A and B into just one that says a title sheet showing the title, labeling or however you want to say this, but a title sheet containing a title labeling the company, type of proposal, and location. And then B would be a locus map showing all major roadways within 2,000 feet. And then in that same section under I, the last punctuation should be a semicolon, not a period, because you're still in your list. And then on U, I had a question about the locations of woodland areas with trees of 6-inch caliper or larger. So you could start this theoretically at a time when the trees are 5 inches, and then in a couple of years they're 6. So now your woodland has changed. I'm going to defer to John mostly on this one because he's the one with most knowledge about this area. So I don't, should we have a periodic reevaluation of the surrounding woodland areas or something like this? I don't, if we're going to try to be aware of the locations of woodland areas that have trees of that size, but then never look at it again when the trees become that size, are we creating a problem, or is it immaterial? I don't know the answer. I'm just wondering what you think.
I guess I hadn't really looked at this or thought about it, but I think what they're trying to do is prevent clearing in areas where there are already larger trees and just allow them to get larger.
So I'm wondering that if this facility might abut a woodland area close enough that then the trees are going to create a canopy that the owners later don't want, that they can go in and cut those trees down because they can say, oh yeah, well, they weren't 6 inches when we put them here, so they're fair game now. I don't know that that's really what would happen. I'm just trying to think ahead of where the loopholes might be.
John, how does just describing trees in this bylaw connect with people who just log their land?
Yeah, I don't really know. I think what they're looking at here is to only clear areas where they're not fairly large trees already growing and protect those areas. And if some clearing has to be done, it would be in areas that are mostly brush or small trees, but
What if a landowner
yeah.
logs their land and then says, I want to build a battery energy storage facility?
Well,
This doesn't
presumably
say
they
what
could. But I wonder, this is a section of this bylaw I'm not totally familiar with, but I'm wondering if the concern about large trees is something that's left over from the solar bylaw.
Yeah.
In other words, I don't see why having large trees nearby or not. I mean, I can see not wanting to cut down big trees, for this kind of project, but trees growing up, don't affect the storage facility, the battery facility. That's not dependent on having, solar access, for example.
The other thing is, this doesn't actually say anything about what's going to happen to the trees. It just says this is what you have to provide for documentation.
Well, it does say that that this documentation has to show which portions of the woodlands will remain in place and where the woodlands will be removed. So,
But it doesn't say what must happen to them. This is just information that'll be gathered to give the ZBA the opportunity to make decisions.
Okay, so it's not saying you can't log your land then,
No,
No, I don't think so.
right?
well, I guess if the trees are, close enough, that would be up to the ZBA to decide. Um, well, I think it's too close or something like that, right?
I think a lot of even the woodland in Shelburne is maybe covered by the Chapter 61,
Mhm.
which has to have management plans and cutting plans about what and when you could cut something. So,
Well, and
A lot of-
again, these things aren't going to be built far from the place where the energy is being produced. So the biggest disturbance to the landscape is going to be the thing that's producing the energy more than the battery storage.
Yeah.
I think we just have to hold on to that idea that those things are really they're going to be close to one another.
Actually, the controversy around in Wendell seemed to focus on a site that the BESS was not located near anything, as far as I could tell.
And how are they getting energy to store in it? Like what?
Probably a high-powered line going to the site that's feeding
But,
it energy.
but like from where?
I don't
wasn't
know.
Wendell
I don't
about solar?
Maybe, but when you looked at the map of the proposed facility, it was kind of off on its own.
That's so odd. I'd love to know more about that, actually.
Yeah.
That'd be
Uh, just for food for thought on this one, why don't you just lop out everything, the words with trees, 6 inches caliper or larger, and just take those words out. And the intent of that item U is still there.
I like that.
I don't
That's a
see
good
any value
solution.
talking about how big a tree is.
Yeah, we're really interested in where the locations of the woodlands are. I think that's a good point, Rick.
Just take those 7 words out.
Yeah,
All right,
I
that's-
think this must have come from a template that Faith Williams got
Yeah,
from another
right.
bylaw, and something we hadn't really thought about, but it's maybe something that's not necessary here.
Right.
On the next page on number 9, I think it would be a good idea to add in accordance with section 19.6.7 regarding the noise. So that section 19.6.7 was pretty specific about where the acoustic engineer needed to do their work, acoustical engineer. So I think the documentation provided by said engineer should be in accordance with section 19.6.7. I would like to see that added. Other than that, I liked the visuals too, so we could see what they look like. And thank you all for all this work that you've done for us. I really appreciate your commitment to the town, and your service to the town is really, really, I find it very admirable, and I thank you for that.
Well, I wanted to thank you for giving us this input because so often we propose bylaws and try to do informational meetings and public hearings and no one comes, and then we get to town meeting and you get all these questions. So it's very helpful for us to get
Absolutely.
input from Select
Uh-huh.
Board and ZBA, and so it's big
Yeah.
help to us too.
Up, Andrew.
Oh, just before we go on, a couple of small notes with the proofreader cavalry here, but on your very first line there where it says section 19.0, the word systems is misspelled.
Yes.
And and then you might want to go through with word find just everywhere there's a mention of BESS and come up with a standard notation because you have it in parentheses in some places, not in others. You have it with an apostrophe in some places and not in others. 19.2 best installations needs a space. 19.2.1, it's italicized. So and there's a lot of references where it's just, a mishmash. So that would make it read more cleanly if you just do a little word find and go through it that way. Similarly, with the notation on kilowatt, you have small k, capital W. I would just make it standard with whatever you have in the solar bylaw. So those are just proofreading notes.
Yeah. So there's one of the things that's on my mind, that's a concern of mine, that was brought up by this particular bylaw, but also is relevant to the other sort of large scale technologically based bylaws. Large sort of solar and other telecommunications is another one. So that and even our same issue comes up with a subdivision bylaw, because there's all these provisions about, okay, you have to have you have to put up a bond, or you have to do something, put up some cash or something like that to make sure the project gets built, or when the project has its useful lifetime has run out, how do you decommission it and restore the land and so on. Those I did some research years ago about this, and I talked to a company in Springfield who issues bonds for these kind of things. And there were two issues. One, the cost of all these things goes up every year, and the companies who have the bonds are not necessarily increased in terms of amount, but also when these companies these projects are usually owned by an LLC, which is a separate entity, a subsidiary of the larger corporation that's putting these things together. And so those LLCs don't have any assets. And so what this bond guy said was that companies just walk away. They say, okay, fine, you got a $50,000 bond, sure. Now the town of Shelburne has $50,000 to go fix the problem. And so it's a bigger problem. I don't have a clear answer about what to do about this, because we're entering into complex technology issues and projects that are going to be, that are going to come, we're going to have to deal with them in 20 years or maybe more. And so I don't know the answer to that question, but it's something that I want to do some research on to see if we can come up with a way to address, so we don't end up getting stuck with these large companies giving us a project, which then runs out in 20 years. And then they say, see you later. Here's your $50,000 or whatever. It's, it's drives me nuts that people can walk away, and they do, and I've seen it with subdivisions where they don't complete the subdivision and they just walk away. So you got some money to spend putting in the road, so go for it, but it's all now the responsibilities on the town. to complete the project. And that's,
Well, Buckland has one of those subdivisions up near the power generating station where somebody built 5 houses and left 5 cellar holes after the town denied their zoning ability
yeah,
to do that.
right,
And
exactly. So
yeah,
anyway, so it's a problem that the standard way of dealing with it, I don't think is adequate. So I don't know what the answer is, but it's on my mind to see if we can come up with a creative solution to not get ourselves stuck with a mess 20 years from now.
Good.
So does
And-
that mean you want to submit something else added to this or
No,
what?
no. This is a
Okay.
project it's I don't know the answers. It's going to take some research. And so, it could be that I want to come back in a year and say, okay, here's some things we want to add to the, all these technological bylaws to revise, the way we deal with the future.
Great.
Okay.
well,
Thank
we
you, Will.
also will have, instances of the town having been left with other kinds of properties that have hazardous waste on them and abandoned houses or, century-old mills that owners have walked away from.
Yeah.
The problem is there, not just in the future technologies, but in people abandoning their property.
Right, exactly. But at least we can, given that we're giving, big companies permission to come in and do something to make themselves a lot of money, at the very least, we want to make sure they don't say, thanks for the money, see you later, here's your mess.
I think
Right.
that's a great project for down the road. Let's stick to the mission.
Yeah, okay.
And, Andrew, you have more on the proposal
No.
as it sits.
No, I don't.
I just have one thing left that has two parts. On the very second page, the 19.4, 2, 3, and 4. Again, for the goal of clarity, you pick this up, you read the first page, you get to the second page, and you're here. I think it's important, and I like the pre-application conference with the planning board, but I think you should resequence those three. I think pre-application conference should be 19.4.2. I think the special permit should stay where it is as 3, and the building permit should become 19.4.4. Then you have the proper sequence that tells people, here's what you do first, here's what you do second, here's what you do third. And if you did that, go to 19.10.2, and there's no reference under application requirements of the previously mentioned planning board conference in advance as the number one step. I think you should add it there too. Just for coherency as you read through it. Otherwise, I thought this was one heck of a project you guys have done, and I'm very impressed with all the work and the feedback you've gotten tonight on it. I think that's everybody's input on BESS. Is that what you call it? BESS? All right, last one. Accessory dwelling units. This is also a zoning bylaw we have in front of us. Tricia, you're up.
So my first comment is again about the parking. I think if we want to just maybe even, I don't know if we can eliminate the parking space requirement, but if you think we can get away with making it a requirement, I would recommend removing that. And then under the table of use regulations, I don't know what's missing there. It just says residential uses, and then it says C, and where it has residential uses, that row, so residential, agricultural, all the way across.
That was the top of the table of use schedule, and some of these have a footnote at the bottom, and that would
That's
refer
what
to
that
the
is.
footnote. So that's nothing to do with this line, but something
Okay.
below probably had a reference, asterisk or a double asterisk to look at a footnote down below. So
Okay.
that doesn't refer to this one at all. And the other
No,
thing
I
on that
think-
line, we were just going to change to what the new state bylaws, they call these accessory dwellings, and our current bylaw said accessory apartment, so we're just changing apartment to dwelling so it matches the states.
That's
And
great.
up above, we basically took the new state definition and used that to replace Shelburne's current definition. And there weren't a lot of differences there. Shelburne was a town that already had ADU bylaw. So we just, changed a few things we had 800 feet and the new state suggestion is 900 feet and no more than half of the gross floor area of the principal dwelling. So we just basically took the state definition.
That's
Putting
great.
that in.
The parking, coming back to the parking, I'm pretty sure the state bylaw says you can't require parking if the unit is within a certain, like a half mile or something of public transport. And so it's so the village and all of Route 2 is obviously, within half a mile of public transport. And so it's so we can't have, we can, if we just use the same bylaw from the state, we can just put in parking is only required if you're not within half a mile of public transport.
Okay. That would be great.
And I guess we'll run this by the ZBA. I'm not sure if they've seen that yet, but in the past, I believe the planning board has tried to reduce the amount of parking required in the village, but we've got some pushback from the ZBA about not reducing parking too much in their opinion. So
I think what Will says, if we're just trying to comply with what the state is requiring, that would be the best way. Just say, we're going to do what the state says. The AG might bounce it back, and we don't want to be in that situation where then we have to do another vote, right, at town meeting or a special town meeting.
Yeah, if we track this new state law, the AG's office is not going to bounce it back.
Right.
Okay, Andrew, any thoughts?
Just curious about that sentence that's 3 from the bottom that says no more than one curb cut or driveway access shall be permitted. Does that mean that all of the lots in the village that have more than one curb cut are non-compliant or non-conforming? Because there's a lot of them, including my house.
Well, there's I think upwards of 80% of all the lots in the village are non-conforming anyway. So
right. No, I'm just curious. Is that your understanding that those are all non-conforming curb cuts?
I haven't thought about that issue at all.
Yeah,
So
probably. We know they're non-conforming lots, so there's probably a lot of curb cuts that are non-conforming too. They've been there quite a while.
Okay.
Right.
Yeah, I mean,
really
my house
thought
was
about
like
this.
that when I bought it. So
Yeah.
it was a rental, that had 2 driveways,
Yeah.
Right.
So are we wanting to add that there shouldn't be any additional curb cuts? Or if you've got, sorry, here's the COVID coming back. That if you have one, you can't get another one unless you go through the ZBA or the planning board?
Well, the wording here is already approved from the state, right?
This last sentence, didn't that come from the Leiden bylaw that we were looking at also? I don't remember if this was part of the state.
Yeah, I don't remember.
No.
Part of the state, we ought to leave it alone, as Will said. They're not going to
Right. I'd have to look at that. It seems like I remember we thought there should be something about parking when we looked at the Leiden bylaw.
I don't see it
we
as a
got-
big deal anyway, because it gives you
No.
guys the ability to determine if a second one is needed. So I don't
Right.
see why it needs messing with.
Yeah, it's fine.
Yeah, I think that was our feeling too. So,
Yeah.
Well,
I
you
don't
guys
have
are
a,
awesome.
I don't have an objection to this bylaw in general, except for the big issue which Al Norman has raised in the op-ed page, which I am in agreement with him on, is I don't think that investor-owned housing should be permitted to have ADUs. I think that's a mistake on the governor's part.
Good. And I have no further comments on this particular one. So I think we've covered all four. Two zoning bylaws, two general bylaws. You guys were very productive this year, so hats off to you, as Tricia mentioned earlier. You guys are doing great.
So
Guys,
will you guys send us back the two general bylaws with the updates that we discussed here?
Right. We've got a meeting January 7th, and we'll try to do as much updating as possible and
Right.
certainly get it out to you and the ZBA and advertise as much as we can, because we want to get as much input as possible now.
Yeah.
I
So we
wrote
have an
down some notes here, but
information meeting later in January and then a public hearing. And so all of this stuff will get crystallized into relatively, final form.
Can I just ask which ones are we considering? Because I understand the short-term rental one is sort of part general, part zoning. So which ones are you saying are the two general and the two town? Or the two general and the two zoning?
the ADU is zoning.
All right.
Mobile.
The energy storage is zoning.
Okay.
The
Mobile food is ours, right?
mobile food is general,
Right.
And
and
short-term rental. That
That's
should
Short-term
be
rental
ours
is general too.
But it's got some zoning bylaw amendments in it too.
but
At
it's
least we've got some feedback. We've got some feedback from Megan Rhodes at FERCog, and she's sort of suggested some pieces should go in general, some pieces should go in zoning.
that'll
And
be
we haven't
Well, we
hashed
might
that
have-
out yet.
We'll have to separate those out into separate warrant articles then.
Oh, right,
I know
because
that
the
the-
table of use regulations, that's in there, that's you guys. But the short-term rental bylaw as itself does not have to do with zoning per se, except for those zoning pieces. I see what you
Right,
mean.
exactly.
But Buckland had part general, part zoning, so I'm not fully
well, you
Yeah,
put it all
that's-
in one. Since you had put it all in one, I assumed it had to be one or the other. But if you're going to split it out, then you have
Well, yeah.
five in the town meeting then.
yeah,
Well,
we'll have
there's
we'll have to think about that, because zoning required for most things requires a 2/3 vote.
right, exactly.
And the general
That's right.
bylaws is simple majority, so
Majority.
we'll have to think about that.
That could be the most helpful thing tonight.
Yeah.
all right.
Avoid problems.
Right,
Right.
exactly.
But
All right,
that's
well,
again
it's,
when if your intentions are clearly stated in the general bylaw, then even if your table of use were not to pass, it would still, under the principle of severability, be relatively intact, no?
So I really appreciate the select board, you folks, for taking the time to walk through this with us and to give it your serious consideration, because it's really helpful.
Oh, good. Well,
Well-
thank you.
I agree.
Well, thank you again for all your work.
Yeah, well, thanks for your input, and we'll
Yeah.
send out new versions and send us any more thoughts too, but
And
Um,
Happy New Year.
Happy New Year. Yeah.
yes, same to you. And I guess as far as the planning board meeting goes, I'd entertain a motion to adjourn.
So moved.
Second.
Okay, we have a motion and a second to adjourn the planning board meeting. All those in favor?
Aye.
Aye. Motion carries unanimously. Okay, thank you very much.
All right.
Bye now.
Hi, everybody. Thank you again.
Good night.
Good night.
Good night.
Excellent. Old,
Ooh-wee.
old business. Yeah, how you hanging in there, Tricia?
Hanging in.
Let's move along then. Any
Yeah.
business? Carrie, none? We're good. New business, mileage reimbursement rate change request. You have that in your packet, the explanation from the town treasurer and collector, basically putting us in line with the current IRS standard figure of 70 cents per mile. I think we're currently 60, or it was 67. I don't know what we currently are.
It says we're at 45.
So what's your pleasure on that?
I'm just wondering why ours was so much farther below what the IRS standard mileage rate was already.
We haven't addressed the mileage rate in several years in our personnel policies because so few people submit reimbursement for mileage. It's basically the town clerk and the treasurer when they go to school.
Okay. Well, I think we should approve this. We should just be in line with what the IRS says. I mean, everybody else uses that.
Like to make it a motion and we can discuss it?
I will move that we approve the increase of the town of Shelburne's mileage reimbursement rate from 45 cents up to the IRS standard mileage rate of 70 cents per mile.
And second.
That's been moved and seconded. Any further discussion? Hearing none, we'll put the matter to a vote. Tricia?
Aye.
And Andrew?
Aye.
And I am aye. It passes unanimously 3-0. Any correspondence? I'm sorry, any other business? Next regular meeting is January 10th.
Actually, it
Wait.
should be the 13th.
Should be the 13th.
Oh,
The 10th is a Friday.
I was looking at the wrong year.
13th. Great. Thank you guys for being so sharp. I was obviously asleep on that one. So our next meeting, January 13th. Now, any correspondence? Hearing none. Public comment, none available. A motion for adjournment, please.
So moved.
Second.
And seconded. All those in favor say aye.
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 Y'all have a happy new year and good work. I mean, I'm impressed how diligently you guys went through those 4 documents of bylaws, and good on you. Thank you much.
Thank you. Thank you all. Happy New Year.
See you next
Same. Good
time.
night.
Bye-bye.
Good night.